Hey, good morning, everybody. Welcome to the Law and Crime Network. I'm Michel Bryant, in for Jesse Weber, who's taken some well-deserved time off today. Okay, let's go. Wake up. Here we go. That's actually more for me than for anybody else. It's pathetic. 9 o'clock is early for me. And if you're on the West Coast, 6 a.m., God bless you. That is Richard Ruth on the stand there in the case of Florida versus Grant Amato. He is a gun guy, and he's about to get into the guts of the testimony of at least 3 guns that he looked at in this case. With me is Stuart Kaplan, former FBI criminal defense attorney. Thank you for joining me, Stuart. Good to have you along this morning.
My pleasure. Good morning.
This case is so odd in so many ways. The alleged motive, the manner of the deaths. Let me get your just initial thoughts on this case against the guy who's accused of killing his entire family because, I don't know, an obsession with a cam girl.
Well, this witness, I think, in trying to show the weight of the testimony, the prosecution has done an excellent job with bringing this expert in because the jury wants to understand whether or not the evidence that has been collected, does it tie somehow back to this accused defendant? This is a witness who has pared down so that the layperson can understand it. I've sat with many, many experts. Just in listening to this expert for the last 5 minutes, he's really kind of oversimplified it, which from a juror's perspective is very, very important. You know, it's interesting. Jurors are told a prosecutor doesn't have to prove motive, but when we sit there, we all want to know if, in fact, this alleged defendant did it, why would he have done it? And so we want to try to get away from that from the prosecution's perspective and tie him back to the evidence that was collected. And if we can tie ample opportunity or the fact that this defendant had ample opportunity to be in possession of this firearm, which I assume at some point is going to be connected to the shooting death of these 2 individuals, that is going to build this puzzle tighter and tighter around this defendant.
Yeah, this is a huge question in this case, and that's a good point. I mean, we know there were guns all over the place, but what about the murder weapon? Okay, I'm pretty sure they're not setting up for a massage session there, but let me take a moment to ask Stuart Kaplan, retired FBI criminal defense attorney, about the lands and the grooves and the projectiles and all the testimony from Mr. Ruth. What do we learn from that?
Very important forensic analysis, similar to a fingerprint. Each weapon leaves its own fingerprint or footprint, or however you want to create your own terminology, but each bullet has a specific rifling that can be traced back to a particular weapon. So what he has done now is he has shown that all of these bullets, and by the way, we haven't heard it, but I can tell you these bullets obviously were extracted from the deceased, from the medical examiner's office, and then turned over to this expert for his examination. And so what he has testified to this point is that these bullets are consistent with the same rifling rounds, and then he will be able to then work backwards to say this particular weapon is the weapon that's associated with creating these riflings, which is consistent with this bullet being discharged from that weapon. Very, very important. And you'll see, again, all the pieces come together so perfectly, like a glove. And then, of course, this defendant have an opportunity to come into possession of this weapon. And basically now you have a pretty good case against this defendant.
Seems like we have one more step to go. He's identified 3 different guns and now a number of projectiles. Now, I'm guessing when this table is set up and it looks like the 3 guns are there in their boxes, the crescendo here is these bullets were all fired by this gun. Is that what we expect to see here?
That's exactly right. In other words, this expert is not going to say 1 of 3 possibly. You're going to see him drill down specifically to identify this particular weapon is the weapon that is consistent with the rifling rounds found on this projectiles, and this is the weapon that was used to kill these 3 individuals.
So let me ask you this, because we get so spoiled with DNA and other forensic evidence where it's 1 in 25 billion and makes it sound like nobody but the defendant. How precise is this gun rifling and this evaluation to a specific gun? Is it possible to have 2, 3, 4, 100 guns with the same kind of impressions and evidence?
Excellent question, and no. And so what you normally see is what normally I see is you'll have a image side by side. You'll show the barrel of the weapon, which produces the rifling, and then you'll actually have the grooves that are left on the projectile and side by side. And so if you do a layover or if you do a side by side analysis, it's 1-for-1, meaning that each weapon has its own unique characteristics that would be left for this particular projectile. So if there's multiple Glock 26s, and obviously there are many Glock 26s out there in the universe, or Glock 17, each particular weapon leaves its own unique characteristics.
So it's basically it's a bullet or gun fingerprint. That is fascinating and obviously critical information in this case and in any case involving a shooting. So while they're unwrapping all of the brown red taped envelopes and boxes, we're going to take a break. We'll come back to that courtroom in Georgia and find out, in Florida, and we'll find out what's going on here with the grand Amato evidence. Okay, wow. That is a lot of damaging information. I think we're starting to understand why this is not a case so much about guilt as it is the defense. Just a couple of quotes here to share. Stuart Kaplan's with me, retired FBI criminal defense attorney. First, she starts with, "I'm going to miss you, Joey." He doesn't know what that means. She says, "I shot him. I shot Mom and Bob." Bob, of course, her stepfather, Robert Deans. The mother, Miriam Deans, is this witness's mother as well. He is the half-brother, different father, a father who, by the way, killed himself. So tough sledding for Joseph Carey. Stuart, thoughts?
Absolutely devastating testimony against this defendant. Talk about motive, talk about an opportunity, talk about planning and preparation, talk about the premeditation that this defendant laid and waited for her mother, and then at the last minute bailed, and then obviously subsequently came back. The fact that the wounds to the individuals were to the back of the head certainly are evidence with respect to the characteristic of laying in waiting and catching someone by surprise. When we talk about a self-defense, we talk about it being in reaction to some event that happens immediate, which would arguably be something that you could put forth. This girl, this defendant, trying to suggest that she was a battered child, it may be true, maybe she was abused, but certainly, seemingly from the testimony of this witness, had all of her faculties well together to plan and just plot out the execution of these people. Clearly devastating testimony against this defendant. In no way do I think the argument of a self-defense in any way is going to bear fruit for this jury to let this defendant off with respect to an excuse to shooting these people. Absolutely not. Devastating.
Yeah, and we're talking not just about the guilt, we're talking now about those defenses and punching holes in those defenses based on lying in wait issue and all the other planning that seems to have gone into these murders. Well, let's see how this plays out. Obviously, the defense and the prosecution have very different thoughts on what this witness, the brother of the defendant, can testify to considering his home life. You know, was he a battered child? Did he leave that environment? And if so, what did Nicole Nachtman know about his treatment, and how did that somehow maybe heighten her awareness or fear, and in fact, that made her a battered child? It's all very convoluted and interesting. Stuart Kaplan is with me, criminal defense attorney. How do you feel these guys handled this issue outside the presence of the jury, Stuart?
I think the defense attorney did an excellent job. In fact, her argument with respect to, look, Judge, this is an eyewitness to the ongoing abuse that my client suffered at the hands of her mother and stepfather. So I think it's very, very relevant, and I think she did an excellent job. I think the prosecutor was trying to backpedal. I think he's trying to, and he admittedly said, look, I'm trying to, quote unquote, box her in. I think the judge kind of saw through that. I think the interesting thing, though, I'm going to go back to, I still think the lapse of time, meaning this was not an impulsive act in reacting to some specific abuse at that particular time. Now, arguably, you may have the experts come in and try to say this is the type of event that wears upon a person, and then all of a sudden they come and they lay in wait in a premeditated state, and then they carry out this execution type of murder. I don't necessarily see that being bought by the jury, but I think in this particular situation with the defense counsel, excellent job, and I think she was obviously able to convince this judge to see it her way.
Let me ask you this question, and we've got just a little bit of time here, but let me get your thoughts on this. This is more procedural in practice. How do you feel about calling out the judge effectively? The prosecution saying, hey, with this other witness, you let A, B, C, and D in. I'm just trying to get that same kind of stuff from this witness. Really telling the judge, be fair here. You've already done this for the other side. You got to help me.
No, and that's exactly correct. And we run into this all the time as defense counsel, where a prosecution will get up and basically it's called opening the door up to, oops, I probably shouldn't have opened that door. And then what they're going to try to do is retrace their steps and try to handcuff us and try to tie our hands from jumping through that door they opened. I think you got to be a zealot advocate and you got to keep the judge honest and keep it fair. And I think, again, this judge listened to both sides very attentively, but I think at the end, he's going to give this defense counsel the latitude to explore all of these issues, to include if, in fact, this witness was abused at the hands of his mother and stepfather. I think it's going to be very compellingly interesting. However, I'm not so sure at the end of the day, will it be able to be bought by...
Stuart, I'm going to have to leave it right there, buddy. I appreciate the insight. Former FBI student, criminal defense attorney Stuart Kaplan. We will be right back to the Law and Crime Network.